Hello guys, welcome back to our video updates. Today's question is going to cover different scenarios when real estate has already been transferred to a third party and a refinance needs to be done. So the question that we received is, how will the refinance actually work out and what party will be doing the refinance? So I'll go over the scenario first to make sure that you're clear on the context. The first person that asked us this question was a client of ours that we helped to transfer real estate from the individual's name to an LLC. And so the individual took out a mortgage at the time of purchasing the property so that the loan was still in the name of the individual. So remember that with real estate, you have usually two different instruments or documents that are involved if the person is purchasing with some sort of financing. If the person is purchasing with cash outright, then all you need is a warranty deed from the seller to the buyer. Because they had financing and took a loan from a lender, the loan was actually in the name of the husband and the wife, and then we went on and transferred the title itself to the LLC. So the LLC is not the one that's the borrower on the note. The couple will still be the borrowers on the note, but the LLC now has title in terms of ownership interest in that property. So their question was, if we want to refinance in the future, would we be refinancing in our name? So they wanted to know what would happen if they do decide to refinance in the future. And so I explained to them that to do the refinance, we have to look at the note itself, the loan, because what you're refinancing is actually the loan and the way the transfer was done. So when you're doing the transfer, it depends on how the transfer of the title itself is done. Sometimes people transfer as a gift to their children, and sometimes people transfer with an understanding that the new party that has title would assume the mortgage note. So in the instance that the party assumes the mortgage note, then that's the party that will be doing the refinance. So in this case, the LLC assumed the mortgage note. The main reason that you would want to put inside the deed instrument that's transferring the title that the party, the LLC is assuming the mortgage note is so that you don't trigger that due upon transfer clause, because the mortgage lenders, they want to feel secure that the property, which is their collateral, is still in possession of the original owners as much as possible, or at least that their note is secured. So their security instrument is the deed of trust that the borrowers signed, and the collateral is the property itself. So when we go about transferring that property to a new party, there is a clause inside the deed of trust that says that if we transfer without the permission, the express consent of the lender, that the lender has the right to call the note due all at once. So let's say that the couple took out a 30-year mortgage and then went ahead and transferred the property into the LLC's name without getting express written permission from the lender. Then that means that in year 2, if the lender finds out about that transfer, or if they find out in the future, the lender has the right to object and to say, we want all of our money now. Instead of it maturing in 30 years, they want the whole amount right now. So that's what it means to call the note due or the mortgage due. And that's the due upon sale clause or due upon transfer clause. If you hear you'll hear it in different ways, but that's what that means. So in order not to trigger that clause, it's usually wise to go ahead and mention in the deed that's transferring the title to the LLC or to whomever the third party is, that the third party will be responsible for the mortgage payments. And that makes the lenders, of course, feel more comfortable about the whole scenario. It does not usually happen that they'll call the note due, by the way, even if you don't mention that in the deed document. But that's just something that's smart to do as a practice. And so that's in the instance if there's an assumption in there that's implied in the deed, then the party that's going to do the refinance has to be the LLC, because the LLC is saying that the LLC is now responsible for the note. So the LLC will be the one to do the refinance. because the LLC is also the one on title at the moment. They'll do the the LLC would be the one to request the refinance, and if the LLC has assets to back up the request for a loan, then the loan will be approved, and that new loan, which is what a refinance is, would be used to pay off the old loan that was in the name of the individuals. If the LLC does not have enough assets to be able to do the refinance, then the individual owners, the original owners, might consider then transferring the title back into their individual names so that they can use their personal credit to qualify for the refinance. So that's the quick answer to that question. I know I'm going about it in a roundabout way, but I wanted to give you some contextual information or background information so that you understand how all of that works. In the case that the property was deeded as a gift to somebody else, then what changes? Well, nothing really changes, in all honesty, even if the document does not say that the person is assuming the mortgage, which if you're giving me a gift, most likely I'm not assuming the mortgage anyway. So you would be responsible for the mortgage, but if we wanted to do a refinance at some point, which party does the refinance? The original owners that are still on the note that's in the background, or their daughter or son that they gifted the property to. So in practice with the lenders would want refinance to be done by the owner of record. So the owner of record of title is going to still be that daughter or son, but the original loan is still in the background. Original loan, remember, is still in the background, which is the responsibility of the parents. So if their daughter or son decides to then refinance, that means her new loan or his new loan would pay off the old mortgage that was owned by the parents. So it's still the same answer. It's just slightly different explanations for it so that people are clear. Normally you don't gift somebody, and normally you shouldn't be gifting somebody real estate that still has a loan on it. It should be free and clear. But in some instances in real life, people do creative things, and family members, they do partial gifts where I give you the property, but you are responsible for making the payments, but they don't put it inside the document. But in either case, the owner of record at the moment is the one that will do the refinance. And if the owner of record does not have enough of a credit profile to pull it off, then you can consider doing the transfer back and then doing the refinance. But then again, that means that the original owners are now still on the hook even more, because they were on the hook originally in the background and now they're on the hook again. So you're ratifying the understanding that you as the parents are actually the ones responsible for the loan. So there are creative ways that people can do things, and this is the answer for that scenario. And the other related question we had is not really about a refinance, it's more about a person trying to assume a mortgage, and the husband and wife are no longer together. They're on title, on record. They're the ones that had the mortgage together, and they're also both on title, because remember, the promissory note has to do with the loan, and the deed, the warranty deed, has to do with the title. And of course, there will be a deed of trust that's tied to the promissory note. So the husband and wife had the property together, and now they're divorced, and husband is trying to do an owner finance sort of deal by allowing a third party to assume that note. So he was asking who would have the right to do it, him or her. Well, that's a question actually for divorce court, because the divorce court would tell us who was actually awarded the property, or if both were awarded the property, which one of them would have a superior right to negotiate deals and close on transactions and things like that. And sometimes neither does, and they both have to come together to an agreement in order for any of them to be able to do any kind of deals at all. So that's the quick answer to that particular question. And of course, it still goes the same way. If the husband now wants to refinance in only his name to remove her name, it has to be through the court order unless she consents to it. And most of the time people don't consent because the communication has completely broken down at this point. So you will have the option to get that inside your divorce decree. Make sure to get that if you're in the middle of a divorce and it's not yet done. If it's already done, your only alternative is to go and ask for a modification of some sort, of that decree, a clarification of that divorce decree, or you might have to end up doing a partition lawsuit. So those are the different ways that you go about it. So you as one party, either as the ex-husband or ex-wife, then you will be able to have a court order that makes the third parties comfortable that you are able to do a refinance just by yourself. And it would also make title companies comfortable in closing any deals that you enter into. So that's our quick response to those questions. And if you find the video helpful, please make sure to like the video. And if you have specific questions about your particular situation or a situation for a friend or family member, remember that the best way is to consult with a lawyer in your state, because different states have slightly different laws, and some have vastly different laws. So these are just videos for educational purposes to kind of give you an overview and to at least give you some things to think about, so that when you're doing a consult, you'll find it more beneficial and you'll be able to connect the dots more easily. And if you like our channel, please do subscribe and hit that notification button so that you'll be getting notifications of the future videos on the channel. Thank you as always, and I'll see you next time.